Okay, so this is my first YouTube video. If you don't know me, I'm JayTee Talks Money. I own a financial education firm as well as a credit restoration company where I was going to say entrepreneurs. I help people fix their credit, and I also teach people how to maximize credit, how to repair their own credit, or if you don't want to repair your own credit, I'll do it for you. So probably know me from TikTok or Instagram, but one of my most requested topics is collections. And I've done a few videos on TikTok, but there's only so much that you can fit in a 3-minute video. So I put together this presentation so we can go over it and I can actually show you guys how to properly dispute your collections. So it's going to be step by step on how to successfully dispute collections and pretty much just all things collections and how to get them off your report. So let's just go straight into it. So, what are collections? Collections basically appear in your credit report in a few scenarios. When an account goes delinquent or is delinquent and is transferred to either in-house collections or an outside collection agency responsible for overseeing and collecting the debt on behalf of the original creditor, or two, when a debt is purchased by a debt buyer. Now, most times a debt buyer will be an attorney or a debt collection agency, and the difference between the two is with number one, when people or collection agency is contracted to actually collect the debt, the money and the debt is still with the original creditor. Whereas a debt buyers usually get debt 3 or 4 times over. So it might go from one debt buyer to another debt buyer to another debt buyer. This is good for you because now it's no longer with the original creditor. And if it's been sold 3 or 4 times, they probably can't even reach out to the original creditor to get that information because they didn't buy it from them, if that makes sense. So that's why you need to know the difference with a debt buyer and a debt collection agency. Now, most times debt buyers are still collection agencies, but you'll see later on why that makes a difference. So just a few important notes that I feel like I need to let you guys know before we get into this. So paid collections affect you the same amount as unpaid collections. The only difference is one is open and one is closed. The goal should be removal. And I say this because a lot of people come to me and they'll say, well, I just want to pay the collection. It's not that much. I can pay it. Yeah, you can pay it. But at the same time, like I said, it doesn't affect you any differently. So I've seen people pay collections off and their score doesn't move not 1 point. So because once it's on there, the damage is already done. So you want to make sure that you try to get it removed. It's fine to want to pay it. You can try to negotiate a pay to delete, which we'll talk about later on in this presentation. But don't just pay a collection just to pay it, because I promise you, unless you're trying to purchase a home or a lender is telling you that it needs to be paid and zeroed out, try to get it removed. 2, if you're successful in getting your collection account deleted, that does not mean you don't owe the debt, nor does it stop it from being reassigned. So a lot of times people will say, oh, I got my debt collection removed, but it popped back up later on. That's, wow, I can't even talk. That's more than possible. It's possible because, like I said, it doesn't absolve you from paying the debt. You still owe the debt because 9 times out of 10 is really your debt, unless it's, identity theft or whatever, that's separate. But once you get the account deleted, you really should try to settle it. And like I said, we'll talk about that later on as well. But if you're getting it removed, sometimes it never comes back up to haunt you, but sometimes it does. And I would hate for you guys to, have your debt collections removed and then you're 30 or 60 days away from the closing table and a collection pops back up. So what I really recommend is if you are able to get your account deleted, you want to go in later on and settle that account with them. Because again, like I said, we'll talk about it later, but when you settle it after it's been deleted, you have way more wiggle room and way more negotiating power. Sometimes disputing a debt will result in a collection agency suing you for the debt. Midland Credit Management is one that are known to sue. So you have to be okay with that risk going into this, that sometimes they will try to sue you. Sometimes they get salty because they can't verify it, and they'll go ahead and try to sue you. And the courts are different than the credit bureaus because, again, the FCRA is what's helping you dispute things off your credit, but court systems are completely different. They don't require the same type of validation, especially if you truly do owe the debt. Learn your state statute of limitations for debt collection. You cannot be sued if you're out of the statute of limitations. So a lot of times the debt statute of limitations is anywhere from like 5 to 10 years, depending on your state. So if you're outside of the statute of limitations and you get it deleted, then you don't have to worry about, them suing you because legally they can't. Effective July 1st, 2022, all paid collections must be deleted from your credit file. This was passed a few months ago. So if you have a collection that you paid, so like that is different than like the paid because that was recent. from number one. So if you paid your medical collection, it's going to be removed off your credit file. So medical collections, if you want to pay those, you can get them deleted. But I still will try to go through the HIPAA violation, removal process, and that way you could probably settle it for a lower amount. But again, that's later on in the presentation as well. And starting in 2022, all medical collections with a balance of under $500 must be removed if they're reporting. Going forward, medical collection debt under $500 is not allowed on a consumer credit report. That was also a part of what was passed back in July with the medical collections. So those are just a few important notes to get out of the way before we get started. Now, how can collections be removed? Debt collectors or debt buyers are governed by the Fair Debt Collection Practices Act, also known as the FDCPA. The FDCPA protects consumers from unlawful collection practices. The credit bureaus are governed by the Fair Credit Reporting Act, also known as the FCRA. These two go hand in hand in making sure that your credit report is free of inaccurate, unverifiable, invalidated, and erroneous information. Per the FCRA, you have the right to request an investigation on any items that appear in your credit report, regardless of why you want to investigate it. That's so important because a lot of people are listing reasons on their dispute letters. You don't have to give them a reason on why you're disputing something. If you're saying that you want it verified or validated, they have to go do that. You don't have to tell them why you want it disputed. Disputing a collection. So there are two ways that you can get a collection removed off your credit report as far as disputing: a debt validation letter and a bureau reinvestigation letter. The debt validation letter is a formal request for validation of the alleged debt sent directly to the collection agency reporting the debt. Works best if it's not being collected by the original creditor. So if you have someone like Portfolio or Midland or whoever, if they're a collection agency actually reporting the debt, a debt validation letter works best because a lot of times they're going to just remove it from their file and they're going to send it back to the original creditor and delete it from your credit report. A bureau reinvestigation letter is a letter sent directly to all credit bureaus reporting the collection, requesting that the bureau launch their own investigation into the debt and ensure the validity of alleged debt. So that's you may have to end up sending a reinvestigation letter if the debt validation letter doesn't work, but I always try to start with the debt validation letter if it's not with the original creditor. If it's with the original creditor, I would just go straight to the bureau reinvestigation letter. Now, what should you say in your debt validation letter? When requesting a debt validation, you should include and ask for the following. Include that you're not accepting or admitting liability for the debt. Be clear that this is a request for debt validation pursuant to the FDCPA. And you're going to ask them to provide the following items: the agreement with their client that authorizes them to collect on the alleged debt, original agreement between the debtor and the original creditor bearing the debtor's signature where he or she agreed to pay for the alleged debt, commission received by the collection agency upon successful collection of the debt, complete accounting of the alleged debt, name, address, and of the original creditor, and address on file for the alleged debtor. Now, when you ask them for a debt validation, you want to send all this information because one thing about it, it spooks them. They realize that you know what you're talking about, and if they don't have this validation, along with the other things that we're going to put in the letter, they're scared now. They're scrambling to try to find validation. They only have 30 days per the FDCPA to respond. So we're going to put the fire up under their asses, basically. We want to make sure that they know that we're serious and we want all of this information. Otherwise, it has to be removed from your credit report. So this is the letter. I don't think I can zoom in on it. Okay, wait, I'm going to do this. Give me just a second. I'm going to pull it up so you guys can see it, the actual letter. Okay. Okay, so this is the letter. And you can see up here, you'll just put your name, your address. You'll put the date, reply, debt validation request. To whom it may concern, upon reviewing my credit report, I've noticed a collection account from your company. Be advised that this is not a refusal to pay, but a notice that your claim is disputed and validation is requested. So this line right here is very, very, very important because I told you, do not accept any liability or any admission for the debt because that could restart the clock for them to be able to, remove the debt. Under the Fair Debt Collection Practices Act, I have the right to request validation of the debt you claim I owe you. I am hereby requesting proof that I am indeed the party that you are asking to pay this debt and that there is some contractual obligation that is binding me to pay this debt. This is not a request for verification or proof of my mailing address, but a request for validation made pursuant to 15 U.S.C. 1692 G Section 809B of the FDCRA. So this line is super important because a lot of times when you request certain things from them, they will send you something that does not meet validation standards. For instance, if you have a cable bill that went to collections, they might say, okay, we're going to send you your validation and send you your final bill showing the amount of the cable bill. Okay, if you come down here where it says complete accounting of the debt, that wouldn't even meet, a final bill does not even meet the validation for that alone, let alone everything else you're asking for. So that's why you want to be clear in your communication that you're not requesting verification, you're requesting validation. So then when you move down here, this is when I said we want to make sure that they were serious. My legal team and your legal staff will agree that non-compliance with this request could put your company in serious legal trouble with the FTC and other state and federal agencies. If your office can provide proper documentation as requested in the following declaration, I will require 30 business days to investigate this information. During such time, all collection activity must cease and desist. So when we ask them, like we just talked about, you're going to ask them for an agreement with their client that grants you the authority to collect on this alleged debt, original agreement that bears an original signature of the alleged debtor wherein he/she agreed to pay the creditor. Any insurance claims that have been made by the creditor regarding this account, complete accounting of the alleged debt, verification that this debt was assigned or sold to creditor, address on file for the alleged debtor, name and address of alleged creditor, commission for debt collector if collection efforts are successful, and date this alleged debt became payable. Now, down here it says, please provide me the name and address of the bonding agent in case legal action becomes necessary. Your claim cannot and would not be considered if any portion of above is not completed and returned with copies of all requested documents. This is a request for validation made pursuant to the Fair Debt Collection Practices Act. Okay. We're going to stop that. Add this to the stream. Okay, so yeah, you guys can see. So I just want to read you guys a letter from there. But you want to make sure that you send that letter to anybody reporting a debt collection on your credit report. And then from the moment that they receive the letter, they have 30 business days to get back to you. So you want to make sure that you send it certified and you have your proof of delivery, because if they do not respond, the next step will be a complaint with the Consumer Financial Protection Bureau, which is a bureau that protects the consumers in the financial industry. Now, medical collections. Medical collections are almost identical to normal debt collections. However, since they are medical, HIPAA comes into play. HIPAA protects patients' private medical information. This helps you with debt collection agencies because 90% of the time, the information that they have can validate the debt that they have. That can validate the debt will violate HIPAA. So either they omit the validation that they have and are forced to delete the item, or they provide the validation documentation that proves that they violated HIPAA and they are still required to remove it or risk being sued for violating your medical privacy. The only way they can avoid the latter is by proving that they were authorized to access your medical information, which they were not because you didn't authorize it. No one can give authorization to give out your medical information but you. So if you did not give them permission, i.e. the debt collector, which you did not, they have to remove it. Okay, we're running into the same problem with the letter. So give me a second. I'm going to pull up the HIPAA letter, which is kind of similar to the original letter. Okay, so here's the HIPAA letter. It's pretty similar. You'll do your name, address, city, state, and zip, collection agency name, zip. If you have the account number from your credit report, put the last 4 there. Enter the collection agency's name and let them know that I've recently reviewed a copy of my credit reports and I've noticed that a collection account that was furnished from your company. I'm requesting that you allow me the opportunity to validate the alleged debt. I do not have any knowledge of any outstanding medical bills that I own. I am requesting the name and medical provider that I owe the debt, and I would also like a breakdown of the fees that your company claims that I owe. Understood that this is not a refusal to pay, but a formal request for validation. I am not asking for verification or proof of mailing address. I am seeking debt validation. Please note that I am allowed under the Health Insurance Portability and Accountability Act to protect medical privacy and records from unauthorized third parties. I'm officially notifying you that I did not give permission to my current or past medical service providers to release any of my personal medical information. I'm aware that HIPAA allows medical providers to release a limited amount of information about patients, but anything further is required to have the patient's authorization. With that being said, I have two requests. I'm requesting proof of HIPAA authorization and proof of debt validation. So you're going to ask them to halt all credit bureau reporting until I have validated the debt, provide proof of my authorization to release my medical information to you, bearing my signature and from the original medical provider, breakdown of alleged medical charges, any collection costs, provide the agreement between your agency and the original medical provider, giving you your agency the authorization to collect this debt, and provide the rate that your agency will be compensated upon successful collection of this debt. Y'all, I'm getting tongue-tied. Please accept this letter sent via certified mail as my request for validation of the debt, which I'm allowed pursuant to the Fair Debt Collection Practices Act. It is important to note that suppressing or withholding any information you have received from the original medical provider in order to falsely portray HIPAA compliance is a violation of the FDCPA, because you will be willfully being deceptive even after my written request. I'm formally asking for all documentation that your agency has received from the original medical provider of service in connection with this debt. Lastly, continuing to report the debt to credit bureaus without allowing me to validate it also serves as a violation of the Fair Credit Reporting Act, which will allow me to seek damages from your agency. I look forward to hearing your response within the next 30 business days. Best regards, your name. So, there was a lot to read. Let me pull this back up. So, with that, you send that off to your medical collection agency, whoever's reporting the medical debt on your credit bureau, on your credit report, and I guarantee you 99% of the time, they cannot either validate the debt, and they can, it will violate HIPAA. So if they were to send you something that violated HIPAA, you're just going to turn around and send them another letter saying that I received your validation. The documentation that you provided with in request. Let me start out. The documentation that you provided in response to my request for validation violates HIPAA. I'm requesting that it be removed. If the item is not removed within 30 business days, I will be moving forward with a lawsuit, for violating HIPAA. So it's really just about making sure that you continue to follow up, because you can see results. Now, following up. If you don't receive a response within 30 to 45 days or the agency sent invalid validation, do the following. You want to print copies of the original letter and gather the proof of delivery. So, like I said, when I said send the letter certified, the United States Postal Service is going to give you proof of delivery. You want to gather that. You're going to mail a 611 method of verification letter to the credit bureaus reporting the debt, because at this point, we're going to go straight to the credit bureaus and request a verification of the debt. And lastly, you're going to file a complaint with the Consumer Financial Protection Bureau and include all documents mentioned in step 1. So I'm going to go ahead and show you the CFPB website. Pull this up. So this is the Consumer Financial Protection Bureau, and basically they're on your side through life's financial moments. We're the Consumer Financial Protection Bureau, a U.S. government agency dedicated to making sure you're treated fairly by banks, lenders, and other financial institutions. So you'll go here and you'll submit a complaint. Once you get ready to submit your complaint, you're going to include, I'm not making an account to do this, but just to give you guys just an idea, you'll just write out your complaint, let them know that you requested debt validation, that they either did not respond in the time allotted by the Fair Credit Reporting Act and the FDCPA, or attach the documentation that they sent you and let them know that it violates the FDCPA because it is not proper validation, and send it over to the CFPB along with while the credit bureaus is working on doing your reinvestigation. The two of those working together should go ahead and get the item removed for you. Let's see. Now, next slide. A pay to delete. So like I was saying earlier, some people don't want to go through the dispute process. Sometimes they just want to be done with it, and they just want to, my camera was backwards. Sometimes they just want to be done with it. So it's fine to just want to go ahead and get it taken care of and pay your debt. But you want to negotiate a pay to delete. So Just a few frequently asked questions or need to know things about pay to deletes. Collection agencies are not required to allow pay to delete. There are a lot of collection agencies that will go ahead and delete it once it's paid, regardless, and some of them only do it once you ask for it, and some of them don't do it at all. Second, always get pay deletes in writing on the company letterhead and signed by authorized rep of the company. There's a pay to delete letter inside of my debt collection removal kit. But just to kind of sum it up for you, you just want to let them know that you're not assuming liability. Which was number 3. Always ask for pay to delete in writing and never say anything to assume the debt. Be clear that you do not accept responsibility. Let them know that I saw this on my credit report. I do not accept any liability or responsibility for the debt, but I am wanting to go ahead and get this taken care of really quickly. I'm willing to offer you this much of the debt or all of it, however much you're comfortable with paying. I'm ready to offer you this in exchange that you delete the trade line from all 3 credit bureaus within 30 days. I recommend starting off with 30 to 50% of the total debt, but some of them won't do that. Some of them want all of it. But I always say 30 to 50% is a great starting point, and they can kind of go, you guys can go back and forth and negotiate. But I would not make any payments until they agree in writing that they are going to delete the trade line from your credit reports. This is the last slide. But I just also want to go back over, with settling. So like I said in the beginning, because you get it deleted does not mean that that you don't owe the debt anymore. So if you are successful with the debt validation or the bureau reinvestigation or the CFPB complaint, once it's removed, I highly, highly, highly recommend negotiating that it be, negotiating and settling it. Once it's been removed from your credit report, they've lost most of their leverage. All they can do is sue you if you are inside of the statute of limitations. So that's the best time to negotiate it. Once it's been removed, you can go ahead and send them a letter saying that I was pleased with my collection, with the collection being removed from my credit report. Although I do not accept liability for the debt, I would like to make sure that it does not appear later on. I will be willing to go ahead and settle this debt for 30% of the debt or 50% of the debt. Once you settle it and it's been removed from your credit report prior, there's no chance of it coming back. So just know that if you do decide to keep it to not pay it after it's removed from your credit report, there is a risk that it can come back because you do still owe the debt. I hope this video was helpful. Because like I said, collections are my number one question that I get a lot. And I wanted to go into a nice in-depth video versus the 3-minute videos on TikTok. So if you have any more questions or if I wasn't clear on something or you want clarification, let me know in the comments and I'll either do a TikTok or I'll respond to you in the comments. But again, my name is JayTee Talks Money. I'm a financial education expert, I guess you can say. I don't know. But I do financial education. I like to talk money. I like to talk credit. I like to talk finances. So if you want to follow me on any of my social media linked at the bottom, we can keep it going with this financial education. Until next time.